Mejia, the legal director of the ACLU of Utah. I've been asked to talk today about why the ACLU decided to take on the issue of patenting genes from a civil rights perspective. Fortunately for all of you, and most especially for me, not about any of these technical ins and outs of the case. So when I joined the ACLU of Utah about 2 years ago, I myself wondered why the national office had taken up a patent case. Not that I didn't think that the attorneys could do an excellent job, but generally we're known for things like striking down limits on free speech or challenging surveillance state. So kind of did occur to me also why we would fight over the scope of patentability. But as I listen to the stories of the women whose lives are literally at stake when it comes to the type, quality, and cost of the BRC1 and 2 testing available, and when I listen to the stories of scientists like the AMP who really want to study and conduct research on these genes, but are being forced to ask for permission or pay royalties before they could do so, I think that the ACLU's interest became clear to me, and that the regime of granting patents over human genes really does raise some fundamental civil liberties issues. So first, I would say that gene patents undermine the free exchange of information and scientific freedom. And having listened to these 2 panels before, they foreshadowed a lot of my my points here, and we did speak to people in the field obviously beforehand, so it became clear to us before we filed that the free exchange of information and scientific freedom were in jeopardy by gene patents. Second, and very compellingly to me, gene patents did pose threats to people's bodily integrity and women's health. In granting exclusive rights to gene patent holders, the government gave those patent holders complete control over those genes and the information contained in them. These rights to exclusive control interfered with an individual's rights to know about her own genetic makeup, and scientists' right to study the human genome and develop genetic tests. So to grant a monopoly on fundamental pieces of knowledge infringed on the First Amendment rights, which protect freedom of scientific inquiry and the free exchange of knowledge and ideas. So that's the civil liberties perspective in a nutshell. But backing up, I'd like to expand a little bit of some of the on-the-ground facts that led the ACLU, along with our co-counsel from the Public Patent Foundation, to bring this case on our client's behalf. So as you've heard from the professor, at the time that the case was filed, it was the regular practice and policy of the U.S. Patent and Trademark Office to grant patents on human genes. Those patents extend to the holder's ownership and exclusive rights to those genetic sequences, their usage, and their chemical composition. And the life of a gene patent was 20 years. Now, it seems like the numbers have changed, but in 2005, there were 23,688 genes in the National Center for Biotechnology's database, and at that time, about 4,382 had been explicitly claimed as intellectual property. So in 2005, it was about 20% of the human genes had been patented. Apparently now it's up to 30, which just shows you how quickly this is all going. So in addition to the BRCA genes, patents have been granted over genes associated with other diseases like Alzheimer's, asthma, forms of colon cancer, muscular dystrophy, and many others that you've heard about today. So while our case and my remarks focus mainly on the effects of the patent on the BRCA genes, our concerns really extended as a whole to a whole host of other patented genes, and presumably the same effects were being felt in those, with those genes as well. So before our case, there had been no challenge to gene patents that had reached the Supreme Court. In fact, at the time we filed it, had been over 30 years since the Supreme Court had taken a case involving whether compositions of matter were patentable under Section 101, which is the Chakrabarty case that was mentioned earlier. And Section 101, as mentioned, is the part of the patent law that prohibits the government from granting patents on laws of nature, natural phenomenon, products of nature, and abstract ideas. So what had been on the uptick was Supreme Court cases that addressed patentability of methods under Section 101. So we sort of felt that the time was right to bring this case about patentability of DNA. So as you just heard from the AMP, It was clear that granting a patent on the BRC1 and BRCA2 genes was inhibiting scientific research and the exchange of information among researchers and from researchers to other interested parties like geneticists, physicians, other health professional applications. And the reason for this was clear. The patent holders have been given full control over the basic components of the genetic sequence. As explained by Nobel Prize-winning biologist John Sulston in an affidavit he wrote in this case, and I'm quoting, "From the point of view of scientific research, human genetic sequences are as basic as you can get in terms of biological information. They are as basic as the elements in the periodic table. Patenting a gene or genetic sequence impedes scientific progress, much the same way that patenting a naturally occurring element such as oxygen or gold would impede science," end quote. And I think that becomes true, as we just heard. You can't really design around a genetic sequence. That's the building block. So not surprisingly, gene patents have the effect of preventing and deterring research by labs that did not hold the patents or licenses. For example, over half of all labs surveyed in the government-funded study reported that they decided not to develop a new clinical genetic test because of a gene patent or license. Another study reported that 46% of surveyed geneticists felt that gene patents had delayed or limited their research. Some geneticists have felt a deep discomfort with conducting research on the BRCA genes in particular because the patent holders prohibited them from disclosing genetic information to research subjects and sharply limited what the holders considered to be permissible research. So I would just say that many types of research related to the BRCA genes were being prevented by the patents. And those included new therapeutics, biomedical devices and instruments, and sequencing technologies. And while some of these new applications related to breast and ovarian cancer, some did not. Whether or not potential breakthrough related to these cancers or not, however, any new advance not approved by the patent holder was precluded by the patents if they required using the BRCA DNA. Indeed, the patent holders could and did use the patent to prevent clinical testing of the genes from other labs, even when the others could do so at a lower cost to confirm results or to ensure testing quality. In addition to research into scientific advancements, the patents also interfered with the ability to deepen our broader shared knowledge about these genes. Scientists routinely share information about the importance of particular genes and particular gene mutations. I mean, you've just heard, generally the attitude is it takes a village, right? We share our knowledge to sort of move the entire field forward together. But since the patent holders maintain a monopoly on clinical testing, they control vast amounts of data on the nature and significance of variants on the BRC1 and BRCA2 genes. As you've just heard, at the time of the suit, Myriad was not sharing the data about these variants with the scientific community, and they had no obligation to do so. If additional labs had been allowed to conduct the testing and share it the way that the other labs did in the example that we were just given, the scientific community could have known considerably more about these variants. So that would have advanced that. The patents also allowed the holders of patents to command not only the law of nature embodied by the BRCA genes, but also the laws of nature relating to how the BRCA genes function in tandem with other genes and genetic factors, as you've heard, those pathways, and how the genes might be linked to diseases other than breast and ovarian cancer. And those are key scientific insights required for the development of personalized medicine. So given these tangible effects on research and knowledge sharing, it's not surprising that 4 of the plaintiffs, including the ANP, were organizations of physicians, geneticists, researchers, clinicians, and other health professionals with combined total membership of over 150,000, as well as 6 leading geneticists. So in addition to these effects on research and knowledge, women's health was also being affected in a very real way by these patents. And you've just heard about some of that. While the patents were in effect, Myriad was, for the most part, the only entity allowed to conduct tests for mutations on the genes that would indicate a higher cancer risk. Many women, upon obtaining these results from Myriad, would have sought a second opinion before they made life-changing medical decisions, such as obtaining or refraining from prophylactic surgery, like removing organs. But the women could not obtain confirmatory testing through other labs, except for in the case of one small set of patients. Myriad also prevented others from providing testing at a lower price or for free. This was especially significant because only 130 million of America's 308 million people currently receive insurance coverage for their testing. So in short, the price for this life-shaping testing was set in the context of a monopoly. And this made such testing prohibitively expensive for many women. The patents were also affecting the nature of the testing of the BRCA genes, and you've just heard about that as well. For many years, Myriad was performing tests that did not identify all known mutations. So sometimes women with mutations that were not detected by these tests were given falsely reassuring results. And you just heard about the issue about the genetic rearrangements. The monopoly on the BRCA genes also prevented other laboratories from including these genes when they were clinically assaying the other 20 known genes that are associated with a hereditary risk for breast or ovarian cancer. And it was impeding the next-gen testing methods. So, as I mentioned at the beginning of my talk, these effects were being felt by real women, and a few of those women are also plaintiffs in our case. So, just moving on to another practical consideration, the ACLU is often asked if we consider the possibility that a challenge to gene patents would actually hinder scientific research in this area, and we did. Our team on this case spent 2 years talking to dozens of geneticists and other experts about possible practical implications of the suit. And it is worth noting that in the Supreme Court case, we submitted an affidavit by Joe Stiglitz, a Nobel Prize-winning economist, and he said that he strongly refuted the claim that without gene patents, private companies would not engage in this sort of research. He observed that this is a constantly evolving field, and that for advancements and innovation to take place, basic data on human genes must be freely available to researchers. He also observes that in critical, in any critical area, slow down with private investment. He observed that in an area this critical, if there's a slowdown in private investment, that government or foundation-supported research would step in if there were a loss. So looking forward, you've heard that there are now lawsuits going on where Myriad is suing other laboratories who are conducting testing. They immediately started to conduct tests after maybe the day after the Supreme Court case came out, and the ACLU and ACLU of Utah have joined as a friend of the court in some of those cases, so I won't really go much into it, but if you're interested, our friend of the court brief is available online.